Mr. No was previously in court in cause numbers 25 DCCR 0386 and 0387, entered pleas of guilty to intoxication, manslaughter, as well as driving while intoxicated with a child less than 15 years old. That was an open plea to the court. We had gotten started a little bit on this hearing, and then I reset it so that the state could, or anybody could, bring any witnesses with regard to statements in the PSI and sentencing. We've all had an opportunity, correct, to review the PSI.
State has, yes, Your Honor.
Other than what we've already discussed and what the defense has filed with regard to response and objections, anything else with regard to the pre-sentence report?
Not from the state, but not at this time, Your Honor.
Okay. There was also a letter from Joyce Barnes, the mother of the defendant, and I have that as well.
Your Honor, I think we had also previously filed letters of support, which the court had reviewed.
Okay.
The state calls Trooper Angel Campos.
Trooper Campos?
Oh, yeah. Trooper Campos, how are you employed, sir?
I'm employed to the Texas Department of Public Safety.
And how long have you been with DPS?
I've been with DPS today almost 3 years.
Okay. Your training and background, of course, includes the academy. I understand you also have some military background as well. What does that include?
I do. I'm working on my 11th year serving in the Marine Corps, and currently I'm a Staff Sergeant E6 in the Marine Corps today.
Okay. Describe for the judge what you observed when you made the scene.
Initially, when I made the scene, I was expecting, like I was dispatched to two vehicles. Then I later found out the two vehicles that I rode up on, one was the deceased's vehicle, and the other one was the witness that witnessed the entire crash. I didn't see a third, but I couldn't really comprehend what had happened because I couldn't find the car that did everything. And then I later found out through on-scene personnel that the...
All right, let's pause right here for a moment because this part of the testimony really sets the stage for everything that follows. The officer just explained that when he first arrived at the crash scene, he expected to see two vehicles involved. But the situation was so chaotic that the car responsible for the crash wasn't even immediately visible. Eventually, they discovered it farther down the road, completely upside down. That tells you how violent the impact must have been. And the driver of that vehicle is the man sitting in court right now, Ray Anthony Noe. But what makes this case even more serious is the fact that prosecutors say his 9-year-old son was inside the car during this crash. So this isn't just a typical DUI case anymore. Someone lost their life, and a child was also put in danger. When you hear cases like this, it raises a difficult question about responsibility and consequences. When someone chooses to drive while intoxicated and tragedy follows, how should the justice system respond? Should punishment focus on prison, or should rehabilitation also be part of the equation? Keep that question in mind, because the officer's next testimony reveals how the defendant behaved right after the crash.
The vehicle that caused the crash was further down the road, upside down.
Did you make contact with the driver or the operator of that vehicle?
I did.
And was he identified?
He was.
Who was he identified to be?
Ray Anthony Noe.
Okay. Your investigation, did you determine if that child was restrained in that vehicle during the crash?
Yeah, the investigation determined the child was not restrained at the time.
When you made contact with this defendant, we're not going to spend a lot of time on it because he's already pleaded guilty, but nevertheless, you observed signs of intoxication, correct?
Yes.
Did he refuse or did he consent to a blood draw?
He refused.
And you obtained a blood search warrant, correct?
I did.
And his blood was drawn pursuant to that blood search warrant.
Yes.
What I'd like to ask you about next and explain to the court is this defendant's demeanor. How would you characterize this defendant's demeanor there at the scene and at the hospital as well?
So his demeanor...
Your Honor, I'm going to object to this to the extent that he's required to. I don't have an objection to him observing what his observation, but to the extent he's going to opine, we're going to renew our objections that we've already made in our response to objections.
That's overruled. He can testify as to what your opinion is as to his demeanor that evening.
Please go ahead and answer truthfully.
The demeanor on that night, he refused to comply with almost every order we gave him. We had tremendous amounts of patience to try and do our job, and he made it every bit difficult. to include the omittance of, allowing us to prove. I even asked him on scene if he could let me do centralized field sobriety test so we can rule out his intoxication. And he refused that too. Try to give him a chance there. Try to give him a chance to consent blood, and he refused there too. Did every trick. Well, it appeared like he was trying to buy time for himself, and he, through my training and experience, we kind of pick up on.
Now listen closely to what the trooper just described, because this testimony could play a major role in how the judge views the defendant. According to the officer, the defendant refused nearly every request officers made that night. Field sobriety tests were refused, the initial request for a blood draw was refused, and the trooper said it felt like the defendant was trying to stall or buy time. Legally, people do have the right to refuse certain tests, so that alone doesn't prove guilt, but in a courtroom setting it can still influence how the situation is interpreted. Another detail the officer mentioned is interesting. During their interaction, he couldn't recall the defendant asking about the other people involved in the crash. Instead, most of the conversation focused on himself and his son. Now that doesn't automatically mean someone doesn't care about the victim. People react differently in shock. But from a judge's perspective, behavior immediately after a crash can sometimes shape how remorse is perceived. So here's something to think about. If you were the judge hearing this testimony, would that kind of behavior affect your decision when it comes to sentencing?
Tricks that DWIs do, and it appeared like he was utilizing everyone he could at the time.
Now, and I'm sorry to interrupt, but we're talking about more than just a refusal or more than just not cooperating, correct?
Yes.
I mean, how would you describe that to the judge?
I would object to leading on that one, Your Honor.
Overruled. Go ahead.
Everything on that night, he, from what I can recall and remember, everything he mentioned or asked, none of it was about the other parties. It was all either about himself or his son.
In your interaction with the defendant that night, you'd already informed him that someone had died as a result of that accident, correct?
I did.
Before you informed him, and even after, did he ask or inquire of you what happened to the other individual or individuals involved in the accident?
Not that I can recall, no.
Is it fair to say that his focus was just on himself throughout your entire interaction with him?
Yes.
Pass to witness judge.
Thank you, Mr. Coleman. Mr. Franklin?
I have no questions for this witness, Your Honor.
All right. Any objection to Trooper Compost being excused?
Yeah.
None, Your Honor.
Thank you, sir. You're excused.
Yes, Your Honor.
It has no further witnesses in the state arrest judge.
All right. Thank you. Any witnesses, Mr. Franklin?
I advised my client about his constitutional rights to testify or not testify. I've advised him against taking the stand. He's decided not to take the stand. I just want to make sure that we put it on the record that he has been advised and he has chosen not to take the stand, Your Honor, and testify. I would like to offer closing.
All right.
arguments.
Thank you. And so, Mr. Noe, you have every right to testify if you would like. Obviously, you've already pled guilty, so there's not an issue with regard to, whether you did it or not. There's been a plea of guilty. If you've talked with your attorney and it's your decision not to testify, is that correct?
I just wanted to apologize, man.
All right. That's good. Thank you. If you want to testify, you can get up on the stand because you'll be subject to cross-examination. So you can't just make a statement to me. If you want to get up on the stand.
This moment right here is actually more important than it might seem at first. The defendant was just given the opportunity to testify in court, and he chose not to take the stand. Now that's completely within his legal rights. A defendant is never required to testify, and the court cannot punish someone simply for remaining silent. But in sentencing hearings, testimony can sometimes make a difference. Some defendants choose to speak directly to the judge to show remorse, explain their actions, or take responsibility before the final decision is made. You even heard the defendant start to apologize just now, but the judge immediately clarified something important. If he wanted to make a formal statement, he would have to take the stand under oath and allow both attorneys to question him. That's a serious risk because once someone is under oath, anything they say can be challenged or used against them. So the defendant decided not to testify. Now the question becomes whether that was the safest legal strategy, or whether it cost him a chance to personally address the judge before sentencing.
I'll swear you in and then the attorneys can question you.
No, Your Honor.
Okay. All right.
want to comment a little bit on the evidence from Trooper Campos.
Sure.
And point out that some of the language used by him about the worst case, et cetera, he just testified he's been with DPS for 3 years. He would have been with them around a year at the time. What the evidence actually showed was Mr. Noe saying please and yes, sir, that he wanted his son to be okay. It was really only in the last video that he had finally learned that he testified that Mr. Johnson had passed away in this case. There's no testimony about him having any knowledge of that in the prior videos. Part of the statements about the reprehensible nature of my client's actions, about how he was belligerent and reckless, I'm not sure that any of the evidence produced by the state, particularly on the scale of belligerent and reckless defendants, actually rises to that level, and nor is his decision to exercise constitutional rights belligerent or reckless. Otherwise, our arguments have been in our written motion, Your Honor, and we've presented information to the court, including the letter from his mother, the letters of support, and the information about his sobriety since the accident.
Now the defense attorney begins pushing back against the narrative presented by the prosecution. His argument focuses on how the officer described the defendant's behavior earlier in the testimony. The defense points out that the trooper had only been with the department for a relatively short time at the time of the crash, suggesting that his interpretation of the situation might not fully capture what actually happened. According to the defense, video footage from the scene shows the defendant using polite language like please and yes, sir, which they argue contradicts the idea that he was acting aggressively or recklessly. The defense also reminds the court that the defendant exercised certain constitutional rights that every person has, such as refusing specific tests, and they argue that exercising those rights should not automatically be interpreted as belligerent behavior. Beyond that, they highlight letters of support from family members and information suggesting the defendant has been working on sobriety since the accident. Essentially, the defense is asking the judge to look beyond this single moment and consider whether the defendant is someone capable of rehabilitation rather than someone who should spend years in prison.
Put the defendant on probation, Your Honor.
Thank you, Mr. Franklin.
Just to hit the high points, Your Honor, this defendant's blood alcohol was a 0.149. He had his son, a child passenger in the vehicle, while he was driving at a 0.149. And that child, his son, who in the video he professed that he cared so much about, was not restrained by a seatbelt. Judge, we have a situation here, but for the grace of God, that his son didn't die, and that more people on the roadway that evening did not die. I think what's aggravating in this case, and I attached a copy of the safety paperwork to my sentencing memorandum, is that this defendant, as part of a probation for felony possession of marijuana back in 2013, was assessed 7 months of safety. And I would think that after 7 months of safety, he would have addressed what, if any, substance abuse issues that he may have had, that including alcohol. I find that him finding himself in this situation, a more egregious situation, could have been avoided had he taken full advantage of the rehabilitative effect of safety, Judge. Mr. Johnson, the victim in this case, Douglas Johnson, got a death sentence, unfortunately, that day, Judge. And I think justice in this case would not lend itself to this defendant walking out.
The prosecutor's response shifts the focus back to the severity of the incident itself. First, they point to the defendant's blood alcohol level, which was reported as 0.149, significantly above the legal limit. That level of intoxication suggests serious impairment while operating a vehicle, but the prosecutor then emphasizes another critical factor. The defendant's own child was inside the vehicle during the crash, and according to the investigation, that child was not restrained by a seat belt. The prosecution argues that this situation could have easily resulted in more than one fatality. Other drivers on the road that night could have been killed, and even the defendant's own son could have lost his life. Then they remind the court of the most devastating fact in this case. Douglas Johnson died as a result of this crash. From the prosecution's perspective, that loss of life means the consequences must be significant. They argue that allowing the defendant to walk out of the courtroom on probation would not reflect the seriousness of what happened.
This courtroom today on probation. I think justice in this case would be for this defendant to spend some time in prison.
Mr. No, these are some extremely difficult cases. When someone loses their life because of your actions. And Mr. Franklin made the arguments and did a great job with his memorandum to the court, trying to point out things and make me think about things in a certain light. Obviously, you didn't get in a vehicle with the intention to kill someone that night, but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone. He also made an argument about that safe P and some of that documentation and the fact that was old, and I shouldn't take that into consideration. I think it's very relevant, though, that you have been through treatment. Even though it's been a while, you obviously had some issues, went through treatment, a serious treatment program where you're in custody in treatment. So you have felt what it's been like to be in custody and still committed this offense. I don't think probation is appropriate in this case or either case. I'm going to find in cause number 25 DCCR 0386. Again, you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0387, also find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger, sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you were in custody that the law gives you the right to receive. I'm going to hand you in each of your cases or to your attorney. He'll give it to you, the trial court certifications that shows these weren't agreements. You do have some limited rights to appeal, and you could talk to Mr. Franklin about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess
After hearing arguments from both sides, the judge delivers the final decision in this case. He acknowledges something important during sentencing. The defendant likely did not get into his vehicle that night intending to take someone's life. However, the judge makes it clear that intent does not remove responsibility. The decision to drive while intoxicated, especially with a 9-year-old child in the vehicle, ultimately led to a crash that killed Douglas Johnson. After reviewing the evidence, the defendant's past history, and the arguments presented in court, the judge concludes that probation would not be appropriate in this situation. The final sentence is 15 years in prison for intoxication manslaughter, along with 2 additional years for driving while intoxicated with a child passenger. Cases like this highlight the devastating consequences that can come from a single reckless decision behind the wheel. Now we want to hear your perspective. Do you think the judge made the right decision with this sentence, or should the outcome have been different? If you found this courtroom breakdown informative, make sure to like the video, share your thoughts in the comments, and subscribe for more real courtroom stories and legal analysis.
a firearm or ammunition, or about how long that lasts, you can also talk to Mr. Franklin. Mr. Franklin, if you'll grab those for your client. Thank you to the troopers for being here, and court will be adjourned.